Okay, looks like we are ready to get started. Good afternoon. As everyone is aware, these proceedings will be live streamed to the public and we will be starting the live stream. This hearing is being recorded and the transcript and video are part of the public record and will be posted on OTA's website. Therefore, please make sure that you don't show any private or sensitive information on the screen. The Office of Tax Appeals is not a court, but is an independent appeals body, which is staffed by subject matter experts and is independent of any tax agency. While the Office of Tax Appeals is not a court, we must nevertheless follow certain guidelines to ensure that we establish a proper record on which a decision is based and to conduct an orderly hearing. Each party will have the opportunity to be heard, so please wait for your turn to present your side. Also, I may interrupt the hearing if we get out of order or it becomes counterproductive, as keeping us on track and creating a clean and efficient hearing record is part of my role as the lead administrative law judge. Today's hearing is being heard by a panel of 3 administrative law judges. I am Judge Ralston, and I will be the lead judge for the purposes of this hearing. Also with me are Judge Clutter and Judge Long. All 3 judges will meet after this hearing and we will produce a written decision as equal participants. Although as the lead judge, I will conduct the hearing, any judge on this panel may ask questions or otherwise participate to ensure that we have all the information that we need to decide this appeal. We are also transcribing this hearing. To ensure that we have an accurate record, we ask that everyone speaks one at a time and does not speak over each other. Also, please speak clearly and loudly. If needed, we may stop you and ask for clarification. And after the hearing, we will produce a hearing transcript, which will also be available on the Office of Tax Appeals website. Does anyone have any questions before we go on the record?
No questions.
No.
Okay, thank you. Panel members, are we ready to go on the record? I'm seeing yes. Okay.
Yes.
Thank you. Good afternoon. We are now on the record in the case of D. Kendall and R. Kendall, OTA case number 2409-17580. The date is October 8th, and the time is approximately 1:15 p.m. As stated, I am Judge Ralston, and I will be the lead ALJ for purposes of conducting this hearing. Also with me on this panel are Judge Clutter and Judge Long. I'm going to ask the parties to introduce themselves and who they represent, starting with FTB.
Good afternoon. My name is Shaw Khan, representing FTB.
Thank you.
My name is Topher Tuttle, also representing FTB.
Thank you. And Mrs. Kendall?
Diane Kendall, appellate.
Thank you. We held a pre-hearing conference in this matter on September 15th, 2025. As we discussed at the pre-hearing conference, there is one issue in this appeal, and that is whether appellant's claim for refund for the 2018 tax year is barred by the statute of limitations. I'm going to correct the minutes and orders, which erroneously stated that the claim for refund was 2016. However, as stated in OTA's acknowledgement letter dated October 15th, 2024, the tax year at issue in this appeal is 2018. Mr. Khan, do you agree that this is the issue and that's the correct tax year?
I do agree, yes.
Thank you. And Mrs. Kendall, do you agree that that's the issue and the correct tax year?
Correct.
Thank you. Also, at the pre-hearing conference, we discussed the exhibits. The appellant has not submitted any exhibits. Respondent has submitted exhibits A through G. Appellant did not object to exhibits A through G, so respondent's exhibits A through G are admitted without objection. Mrs. Kendall, you did submit an email this morning and you attached 2 documents to that email. Were you intending to submit those as exhibits?
I think that the other side has those exhibits. They have the brief already, which I'm going to refer to. But the two exhibits, I would like those exhibits in the to have those exhibits.
Okay.
That,
And those are documents that that FTB had already submitted with their exhibits, or those are new documents?
I'm not sure what they submitted. These are
Okay.
just my documents that I received.
Okay, let me check with Mr. Khan. Did you receive those documents from appellant?
Yes, Judge. The first exhibit, the picture on the right, the statute of limitations, is part of appellant's opening brief at page 3, and the left is a new document to us. This appears to be a 1099G. Then.
Okay, I'm going to ask you to speak up just a little. I'm having a little trouble hearing you.
The document that's attached on the right side, the statute of limitation letter, is available in the appellant's opening brief at page 3. And the 1099G that was attached, that is a new exhibit to us, and we have no objections if that needs to be admitted.
Okay, so Mrs. Kendall, we're going to go ahead and object those as I'm sorry, not object those, admit those as FTB has indicated they do not have any objection. So the document regarding the statute of limitations, we'll admit that as Exhibit A, and the document, the 1099 document will, I'm sorry, not Exhibit A, Exhibit 1. And the document that is the 1099 information, we will admit as Exhibit 2 without objection. Okay. Moving forward, witnesses, respondent does not intend to call any witnesses. And Mrs. Kendall, you intend to testify under oath. Is that still correct?
Correct.
Okay, so in a few minutes before you give your presentation, I'll swear you in. As far as time estimates, Mrs. Kendall, you requested 10 minutes for your opening presentation. And Mr. Khan, you have requested 20 minutes to give your opening presentation. Mrs. Kendall, are you still okay with 10 minutes?
Yes.
Okay, and Mr. Khan, are you still okay with 20 minutes?
Yes.
Okay. So after Mr. Khan's presentation, Mrs. Kendall will have 5 minutes for your rebuttal. As I mentioned at the pre-hearing conference, the panel members may have questions for Mrs. Kendall, and FTB may also have questions for you, Mrs. Kendall, since you are testifying under oath. The panel members may have questions for either party. And it looks like we are about ready to begin. So, Mrs. Kendall, I'm going to place you under oath now so that we can consider your statements as testimony, and you will remain under oath until the close of this hearing. Since you're on the phone and we can't see you, I still would ask that you raise your right hand. And do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You have 10 minutes for your presentation, and you can begin when you're ready.
Oh, I'm first up, huh?
Yes.
Okay. I'm going to read this because I've written it down and my thoughts kind of get jumbled. So here it goes. Dear panel of tax appeals, the last few years have been overwhelming since my husband has had a severe right-sided stroke, requiring 24/7 care. It is so hard to see your husband grasping for air and choking due to his difficulty in swallowing even water. I have been with him night and day for the past 3 years. He is now able to walk with an unsteady gait with his walker, incontinent and dependent on me for showering, dressing, and grooming. After taking him to therapy sometimes 3 times a week and daily exercises at home plus household duties without any extra help, I have tried to get my life and obligations to IRS, Fed, California, Idaho, Montana back in order. Since much of the business and tax issues have previously been taken care of by my husband, this is all new to me. I have been a registered nurse now for the past 55 years as the sole supporter of our household with 3 children. I am now retired at 80. I have experienced 6 years of travel nursing from San Diego to Seattle, Connecticut to Hawaii. It has been a privilege to provide access with several mission hospitals, taking care of underprivileged populations of islanders in the South Pacific, where service was granted free of charge in hopes of eyesight, walking again, or surviving cancer. It has been a very slow procedure since my files for 2018 have been lost twice by the IRS, with multiple letters, phone calls, and complete files resent again. I am now in collections for over $18,000. All my taxes have been filed for the last 7 years within 6 months by my CPA, each year paying the initial fees requested ending on May 26, 24. Now I am struggling with these delinquency penalties, interest, and fees. I have read and reread these 33 pages of 1, 3, and 4 years of limitations created by the Queen of Limitations, Anna Marja Antic Jezik. You can level a fee but not wrongfully collect such a large amount from my bank account. My taxes were $125 for 2018. Now the IRS says they can't refund any of my tax liens due to the statute of limitations and have denied what they say is owed to me. Also a paper saying the IRS owed me $585 for 2019, but not refunded. I have lived in California from 2009 until 2019, trying to understand on page 3 of the brief the 1-year statute which expired on April 15, 20 to May 28, 24, which was when I filed my refund claim. This is exactly 4 years plus 1 month. Is 1 month unreasonable to consider? Praying some mercy. I am contending that when a lien of $8,121 pulled on May 8, 21 is paid for all outstanding back taxes, and all taxes are filed and paid August 2, 2024. I believe you have an obligation to refund the amount you owe the taxpayer or customer. This is a total of 3 years. And down below is 217. I had a refund of $822, but there was no refund because it's too old. In 2018, I owed $125. 2019, I had a refund of $585. We moved to Montana in June of 19. According to 1-year statute of limitations expired on April 15, 21, leaving 3 years prior to when I filed my refund claim. So I claim the 1-year statute of limitations for the $585 refund in 2019. And Thank you very much for your consideration. I am sure that I'll be able to use this money that is owed to me for the federal taxes. Thank you very much.
Okay, thank you,
Diane
Ms.
Kendall.
Thank you, Mrs. Kendall. Does that conclude your presentation?
Yes.
Thank you. Mr. Khan, did you have any questions for Mrs. Kendall?
I do not.
Thank you. Judge Clutter, did you have any questions for Mrs. Kendall?
This is Judge Clutter, no questions.
Thank you. Judge Long, did you have any questions for Mrs. Kendall?
This is Judge Long, no questions.
Thank you. Okay, we are going to move on to Mr. Khan's presentation. You have 20 minutes. Please begin when you are ready.
Thank you. Good afternoon. My name is Shaw Khan. I am a program specialist one at the Franchise Tax Board, and I, along with Counsel Topher Tuttle, will represent the Franchise Tax Board, or FTB, in this matter. As discussed earlier, the sole issue for the 2018 taxable year appeal is whether the appellant filed a claim for refund prior to the expiration of the statute of limitations. And I want to start by giving a quick background and the timeline of major events for this case. Starting in December 2020, FTB issued a series of successive notices to the appellants. These notices included a demand for a tax return, a notice of proposed assessment, or an NPA, a state income tax balance due notice, and finally, an electronic order to withhold. The last of these notices resulted in a collection payment being received by FTB on
Mr. Khan, I'm sorry,
Yes.
if you could speak up just a little, I want to make sure that we get a clear transcript. Thank you.
Just give me 1 second. Let me change out my headphones and maybe you can hear me better. 1 second.
Sure, thanks.
Can you hear me better?
I don't hear anything.
I apologize. I'm gonna switch back. Can you hear me okay?
Oh, yes.
Okay. Um, okay, so I just want to go back to the last of these notices, the electronic order to withhold. This resulted in a collection overpayment that was received by FTB in August of 2021. From this collection, $6,170.20 was applied to the year at issue. On May of 2024, the appellant submitted a joint 2018 California resident income tax return, which FTB accepted. And after making various adjustments to the account balance based on the return, there was a remaining credit of $5,395.82 for 2018, which FTB denied because the statute of limitations had expired. It's that action that led to this appeal. California has a strict time limit for filing refund claims, including tax returns that claim refunds. And there's no waiver of the statutory period for refund claims based on reasonable cost type arguments. FTB is prohibited from crediting or refunding an overpayment when a claim for refund is not filed within 4 years of the due date of the return or within 1 year from the date of overpayment, whichever is later. In this case, the appellant did not timely file a return for the 2018 taxable year, and therefore their claim for refund must have been filed either within 4 years from the original due date of the return or 1 year from the last payment. As mentioned earlier, and in FTB's opening brief, the appellants filed their return on May of 2024, and this date is beyond the 4 years from the original due date of the return, and thus FTB correctly disallowed any credit or refund. If, however, the 4-year statute of limitation has run, only payments made within 1 year of the refund claim can be refunded or credited under California law. The appellant's payment for the 2018 year include a withholding of $1,451 and the previously mentioned collection payment of $6,170.20 that was received in August of 2021. Withholding payments are being paid on the return filing due date, which in this case was April 15, 2019. The collection payment made on August of 2021 was received more than 1 year prior to the May 2024 claim for refund. Therefore, these payments are barred by the 1-year statute of limitations. And accordingly, FTB's denial of appellant's claim for the refund is proper and should be sustained. I'm happy to answer any questions you may have or provide any clarification to FTB's position. Thank you.
Thank you. Does that conclude your presentation?
Yes.
Okay, let me check with my co-panelists. Judge Clutter, did you have any questions for Mr. Khan?
This is Judge Clutter. I just have a point of clarification. So, Mr. Khan, if I understand you correctly, there was a payment made on August 13th, 2021, but of that amount, only $6,170 was applied to the 2018 tax year. Is that correct?
That is correct.
That's my only question. Thank you.
Thank you, Judge Clutter. Judge Long, did you have any questions for Mr. Khan?
No questions, thank you.
Thank you. Okay, Mrs. Kendall, you have about 5 minutes to give a rebuttal if you would like.
Well, the only thing I can say is that the exhibit there that the IRS sent me a paper saying that they owed me $5,395.82. But they disallowed that because of the statute of limitations. This is very hard-earned money, and I just can't throw it out. I believe they took too much money out in the beginning. I'm not sure why they took so much out of my bank account. But I wasn't watching my bank account at that time. I was working away from home, and I was a registered nurse working 3 months at a time in different places, locations. And I didn't pay any attention to these taxes until just lately. So if they send me this paper, it seems like that they owe it to me. And that's all I can do. I don't know about the limitations. That is up to you. Thank you very much.
Thank you, Mrs. Kendall. I appreciate you sharing your story with us. I know some of these issues are quite painful to discuss, so we appreciate that. I don't think that I have any further questions for either party. My co-panelist, if either of you have any questions, looks like there are no questions there either. So we're going to go ahead and conclude this hearing. We are ready to conclude this hearing. This case is submitted on October 8th, 2025, and the record is now closed. The judges are going to meet and deliberate and decide this case, and we will issue a written opinion within 100 days. Today's hearing in the appeal of D. Kendall and R. Kendall is now concluded. This hearing is adjourned, and the next hearing will begin at 2:20.